In a few weeks, the courts across the country will conduct ceremonies to mark a new legal year, and many believe that the start of a new legal year provides a good opportunity to make changes and to put on the front burner issues of judicial reform. Now, the Justice Reform Project, JRP, has been at the forefront of advocating for such reforms. They recently wrote a letter to the Acting Chief Justice of Nigeria, Justice Olukayode Ariwoola, to suggest some urgent and critical reforms, one of which is that priority should be given to court digitalization. This is the starting point of my conversation with the convener of the JRP, Senior Advocate of Nigeria, Adeyemi Candid Johnson.
The fact is that the judicial process and the justice delivery product in Nigeria is so disfigured by maladministration, lack of organization, and lack of ethical and ideological guidance that it would require a dramatic change in many aspects which would amount to a revolution. I'm not so sure whether this or any other acting Chief Justice has the will to achieve that degree of change. But the fact is that since this is a product which is being delivered for the benefit of Nigerians, ultimately it's Nigerians whose dissatisfaction with the system that will drive change. It's interesting because someone asked me about it recently. I was talking about the reforms in Kenya in 2010. You know, they had a constitutional crisis with elections over cases over elections, and they appointed a very distinguished gentleman called William Mutunga as Chief Justice of Kenya, and his job was to transform the judiciary. Now, if you notice, you may not be aware of the time when the Nigerian judiciary was regarded as the lodestar of judicial excellence in Africa and in the Commonwealth. That is obviously not the case today. But Kenya has been recently in the news, election petition presidential, 14 days the decision was given. I mean, these are judges who were appointed by the president who opposed the candidate who has won. The fact is that the process by which Kenyan judges are selected is rigorous, it is transparent, it is highly competitive. This Chief Justice was interviewed on live TV for her job. So you can understand, you know, people have spoken about Rwanda and Ghana and those other countries, but the fact is, the Nigerian judicial system is not today a model of high quality justice delivery. And we would do well to learn from what Kenya did. Kenya had a judiciary which was characterized by lack of integrity, loss of reputation, incompetence. In fact, what they said in one article was that why hire a lawyer when you can hire a judge?
It was that bad?
Oh yes. And this is just 12 years later. So if there's will, many things can be done. But for an incumbent Chief Justice who does not have maybe power, resources, or even the stomach for extensive reform, there are many things that can be done to improve the quality of the product. You know, you can't improve a product unless you know what its purpose is. The purpose of the justice system is to resolve disputes between people because it is inevitable in any organized society that there will be disputes. And it is inevitable that unless those disputes are managed properly in a way that is fair, transparent, and effective, then they will cause further crisis in the organization of and in the social fabric. So that is the purpose. So if that is the purpose, then the job of a judge is to decide disputes. The job of a judge is not to look for mindless technicalities, to deflect from the cause of justice for the purpose of some fanciful idea. It's not his job to use Latin phrases. The fancy dress isn't even important either. The important thing is that people come before you and they know that within a very short time, the dispute will be decided in a way that I can understand, that is apparently fair, and that is consistent. When you have cases, especially corruption cases now, and electoral cases, where the reputation of the judiciary has been so terribly soiled because it seems that the practitioners in that area have an extraordinary capacity to guess decisions of the courts which may be inconsistent. So if a judge decides blue 10 times, then you should be able to guess the third time will be the next time will be blue. But if you can guess it is red, then as Justice Toby said recently, you must be a suspect.
So you've talked about consistency of judgment, fairness, and integrity of the process. And this brings me to one of the points that JRP made in its letter, the need for verbatim and electronic record of proceedings of courts across the country. And JRP has seemingly pushed the burden back to the parties. Why?
Well, that's not unusual. You know, judicial resources and the cost of administration is extensive, and the resources are limited. So you have to manage them, and you have to do as much as you can, that is the government, and you have to allow the parties to do the rest. In a country like America, for example, the system of depositions in civil cases means that the parties interrogate and question witnesses outside the presence of the court. So the court gives an order, pleadings have been settled, witness statements have been received, the parties will schedule between themselves within the next 7 days deposition, and you must go to the deposition. So I want to depose your client, he's in your office, I will go there, and it'll be recorded. So we can then jointly present to the court a record of testimony. These are ways of taking away the burden of administration from the court. And why can't we both agree? In arbitration, we do it all the time. These are parties in no less contentious disputes. We do not have all the resources for all the justice we require. So we must use the resources we have for what we must do. And other areas, there's nothing wrong. Parties are asked, after the courts in Lagos were attacked and burnt, parties were asked to provide the records. So I would go to my colleague on the other side. These are the documents I have. They're all certified by the court. Let's sign off on a paper, joint paper, saying these papers. It's very simple. In the exceptional case where a lawyer is not willing because he's unreasonable or because he's unethical to reach an agreement, then you go to the judge. But in most things, in arbitration, for example, you'll be told the party should first try and agree the order that is required and tell the tribunal. Only if the parties cannot agree will the judge come before. And someone comes before the court and has refused to agree to something which he should have agreed to, the court should punish him. Because the principal function of the court is the determination of disputes. And the principal responsibility of the lawyer is to facilitate the due and proper administration of justice.
But what happens in cases where the parties and even their counsels cannot afford to do that?
That is a problem. You have to deal with, it's like an election. Someone says that if you want to make electronic voting, some areas of the country do not have internet and cannot be reached, they're reached by water. That's true. So let's do the quarter that can be done, and then use the rest of our resources for those that can't.
So the way that you've explained it, it's common sense. It's so easy that, why is it that we're not even going down this route?
You know, nobody's thinking, Willie Mutunga's plan for the Chinese judiciary was called the Judicial Transformation Plan. They studied all the reports, they studied all the suggestions, and then they appointed a chief executive for judicial reform. They appointed a high court judge to study. They consulted widely. My father, my late and dear father, there are many things that he used to say which I remember with gratitude. One of the things he used to say was contentment. In Yoruba, itelorun. The second thing he used to say very often was, common sense is not common. You say, but it's common sense. Yeah, but that man doesn't understand it. To reform a thing, you must know what is the purpose. What is the purpose of system of justice? If you tell them, and we all agree, it's to determine disputes fairly, promptly, in a transparent way that people can understand and which people can predict, then it means that when a case comes before you, you're going to very quickly throw away all these irrelevant technical points. Our judges, especially in the appellate courts, delight in irrelevant technicality. They don't understand that their job is to decide disputes. They think their job is to entertain the public with irrelevant technical points. Unless a technical point is substantive, unless it affects the merit of the decision, there is no reason why it should stop a case from being heard. So, for example, you have this ridiculous question of who signed it, whether it was signed for a law firm or not. If a lawyer appears before the court cannot question his right to appear for his client. If a lawyer comes before the court and says, this document, it's my signature, but I didn't tick a box or I didn't write something, some judges who are not as busy as they should, think that's an important point. The important point is that a qualified legal practitioner has signed the document. Why? For the protection of the public. It's not a technical point to be used to dance away from justice. But our judges, and the appellate courts in particular, like to dance away from the merits of a case. Because the judicial administration is not efficient, judges have too much work. So they use technicalities as a device for triaging cases. If you make a mistake, that's it, we've caught you, you're out. But then it undermines the quality of justice and the reputation of judges. And the second thing is that some of them just can't think very well. Not all of them, of course, but quite a few. Why should you have to beg the Chief Justice to improve administration of justice? I don't understand it. You know, everybody takes a job. The Prime Minister of England takes a job. She immediately goes to announce to the public what she's going to do. The Chief Justice of Kenya produces a report every year on what has been achieved in the judiciary and what they intend to do. If you go to the Instagram page of the Kenyan Supreme Court, every day they will tell you what's happening in the Magistrates Court, they tell you what's happening in Small Claims Court. It's for the public because one of the fundamental pillars of their transformation was that the public should be able to understand what is going on. You can't have confidence in something you don't understand. So this was a fundamental. So here we are. We make these suggestions humbly and respectfully. But I really wonder why we need to remind the Chief Justice that the judicial service is not delivering what the public needs and that there are tools available to address this. I don't know why.
So in all of the time that JRP has been writing to the CJs, giving all this advice about what to do, has the CJs, any of them ever written back to say that we would partner with you to achieve this? Good suggestion here.
No. They're probably still having congratulatory visits, which takes quite a bit of time as well.
3 months.
Well, you know. So that's the situation. You know, if I was given a job, I wouldn't be able to sleep without addressing what needs to be done. My tenure is 2 years. I need to do it. And when I'm gone, I'm gone. If I attend a job and I give it my best, when I'm done, I'm done. But some people take on a job for the glory. I neither have the interest or time for glory. I just think that it's important, if you are regarded highly enough to be trusted with important work, then you should give it your best, do your best, and as they say, leave the rest.
Let's round off with a sort of agenda setting for the NBA. We've recently sworn in new national officers for the Nigerian Bar Association, and I'm just wondering, what do you think that they can do differently, you know, with regards to achieving some of these things that we've talked about, judicial reforms? Is there anything more that could be done? Well,
what we have is a product of a collaboration with the Nigerian Bar Association. That's worthy of commendation. Again, I think that with the last administration, they've done what they can do and they've left. And I think that there is a body of work which indicates that there was some high quality product output from them, and they should be commended. Now, the next incumbent has to consider what he wants to achieve. Being NBA president is no achievement. The job of the leader of what is in fact a professional union or organization is to promote the environment in which that profession will thrive. NBA declares that it is dedicated to the rule of law, but this is not its primary function. There's so many other irrelevant things that NBA does, you know, holding parties, all these things. There's a whole lot of frivolity, but I understand that you need to entertain people, and that's fair enough. But then, in his own quiet moment, the president needs to consider whether there are 3 or 4 things he can achieve. I don't think that you can achieve much by not telling the truth. I think that there are many things that are startlingly wrong. Collapse of ethical values, collapse of professional responsibility, lack of dedication, lack of professional skill, both at the bar and at the bench. But if you take these things on, somebody will be offended and someone may try and put his fingers in your eyes. When you have become president of the Nigerian Bar Association, you should not be afraid of such things. I can tell you, some people may tell you the name of the Chief Justice of Kenya. Many Nigerians know the name of the Chief Justice of Kenya because many of them are reading the decision and they're seeing how this 62-year-old woman conducts herself. And I don't know if you remember the names of the last 3 Chief Justices of Nigeria. I hardly do. I'm a senior advocate of Nigeria. They will tell you about the Wolf reforms and the things that Lord Denning did and the Scott reforms, because these people applied the power that was given to them to improve the quality of justice dispensation. That's enough.
Welcome back. The shameful incident of August the 23rd, which saw lawyers break into the pavilion for the distribution of conference materials, destroying booths and carting away conference bags and other valuables, have continued to generate reactions from lawyers and non-lawyers alike. The president of the Nigerian Bar Association, Senior Advocate of Nigeria, Yakubu Mekel, has inaugurated a 15-member committee to investigate the immediate and remote causes of the sad incident. In this next report, Law Weekly's correspondent, Nifemi Abiola, samples the opinions of some lawyers on how the committee can best do its work.
This is the viral video of that shameful incident of August the 23rd. While their other colleagues attended the breakout sessions of the annual General Conference of the Nigerian Bar Association, holding at the Eko Atlantic City in Lagos. These lawyers threw caution to the wind and brazenly looted conference materials which they were ordinarily entitled to. In the process, they destroyed the registration booth for the collection of the materials and injured other lawyers and registration officers. Many who saw the video condemned the actions of the lawyers, and the leadership of the NBA at that time described the incident as a national embarrassment. The looted conference collection center was swiftly shut, and a new center opened the very next day for the resumption of the collection of the conference materials. Arrangements were also swiftly made to procure more bags with a promise that everyone would get the conference materials. While acknowledging and expressing regret that there were lapses in the distribution process, the NBA president at the time attributed the delay to the low-quality bags supplied by the contractor Untouched Limited and promised that the association will explore legal redress for the dishonesty and violation of contract terms displayed by the company and its CEO.
Our colleagues stole bags. Our colleagues stole phones. Our colleagues beat up staff because we have video evidence. We are going to get the experts to look through those videos. And you have my assurance, and you have YC's assurance that anybody found culpable for embarrassing our association and our nation like this will definitely be sanctioned.
But in a swift reaction, the CEO of Untouched Limited, Mrs. Martha Okopi, has denied Mr. Akpata's claims, insisting that our organization surpassed contractual expectations and duties. In a statement which was made public, Mrs. Okopi said, "We produced the figures asked of, the agreed specification, and delivered same within what is best termed record time. Yes, there was a flop. Yes, someone is to be blamed for it, but no, not Untouched Limited."
What the world saw on social media is not a representation of who we are as members of the legal profession. We remain proud of the nobility of the profession, and we are committed to conducting ourselves in the best traditions of the bar with candor, honor, dignity, integrity, and professionalism. What we saw fell short of this, and we have a duty to deal with that shameful conduct. I hereby immediately, subject to the approval of NEC, set up a committee to be chaired by Mr. Wale Fabonda, Senior Advocate of Nigeria, Attorney General of Ekiti State, to investigate the incident and identify all those who participated in that disgraceful act. with the view to reporting them to the LPDC.
The new president of the bar made this comment in his inaugural speech on August the 26th, and on Monday, September the 5th, he followed through by announcing a 15-member investigation committee which is expected to submit its findings and recommendations within 4 weeks.
Expectedly, lawyers have been reacting to this recent development. Some suggest that the investigation committee should also pay attention to the root cause of the delay in the distribution of the conference materials, especially in light of the denial by the contractor, Antouch Limited.
I believe that they ought to first find out, first and foremost, what caused the looting in the first place. What may have happened that made some lawyers to throw caution to the wind and start looting. And then when they have done that, they'll now go the next stage, which is to find out who are those that were involved in the looting, and then what will be the appropriate punishment.
This committee should also investigate why the committee set up for the distribution of these materials decided to keep away these materials, from distribution before time.
The attendance and the communications is very important. Although the president has sent message, the committee has sent message to members, but most members at the conference will not be able to access their mail. They have noticed that these materials are not enough, or the material supply are substandard. That was the reason given.
Why is it that the conference was so organized and then there were flaws like what has happened? Those that paid for the conference are entitled to conference materials. So in the committee looking at what has happened, they must look at better ways of organizing a conference that will be devoid of this type of shame.
All attention is on the committee headed by the Attorney General of Ekiti State, Olawale Faponda. The expectation is that they will do a thorough job in identifying those culpable in this shameful incident.
On the home stretch, let's bring you a recap of some of the top legal stories in the news.
We begin with the report that the Federal High Court sitting in Lagos has granted bail to the Speaker of the Ogun State House of Assembly, Olakunle Oluomo, in the sum of 300 million naira with 2 sureties and like sum. Justice Daniel Osiago granted bail following no objections from the Economic and Financial Crimes Commission (EFCC). Before the bail hearing, the EFCC had initially arraigned the Speaker alongside 2 other officers of the Ogun State House of Assembly before the judge on an 11-count charge of conspiracy, forgery and stealing. They all pleaded not guilty. Still at the Federal High Court in Lagos, another judge, Justice Akitayo Aluko, has extended the order stopping President Muhammadu Buhari and the National Broadcasting Commission (NBC) from revoking the licenses of 53 broadcast stations in the country. The court also stopped them from shutting down the stations for allegedly failing to renew their licenses. The court granted the order of interim injunction following the hearing of a motion ex parte by the Socio-Economic Rights and Accountability Project (SERAP) and the Nigerian Guild of Editors (NGE). In the case of a former commander of the Intelligence Response Team, DCP Abba Kyari, the federal government has filed a fresh 24-count charge against him for failure to disclose his ownership of different properties located in different locations of the Federal Capital Territory, Abuja, and in Maiduguri, Borno State. The federal government says it uncovered 14 of such assets, including shopping malls, residential estate, polo playground, lands, and farmlands. Over 207 million naira and £17,598 were also discovered in the various bank accounts of Mr. Kyari. In the fresh 24-count charges filed against Mr. Kyari, the Attorney General of the Federation stated that the suspended DCP allegedly disguised his ownership of some of the properties. The leadership of the Nigerian Law School has denounced a viral picture purporting that the school increased the fees for the 2022-2023 session by over 400%. The picture, which was circulated on the evening of the 8th of September this year and which carries the law school logo, generated so much reactions on the basis for the astronomical increase. The Director General of the Law School, Professor Isa Chiroma, has however denounced the viral picture, describing it as the handiwork of criminally minded students who intend to extort their parents. He also says that this false news sadly happens every year. And we round off with a report that the Bar Council of England and Wales says it has been advised by the Crown Office that the title Queen's Counsel QC changes to King's Counsel KC with immediate effect. The announcement was made on its Twitter page shortly after the passing of Queen Elizabeth II. The tweet also says that the change is automatic as there are no new letters patent.
And this is where we adjourn till next week. Don't forget that you can find this episode of the program and past episodes on our YouTube channel. After viewing, be sure to leave us a feedback. I'm Shola Shayeli. Thank you for watching and see you next week.